June 2, 2025. A federal court motion is filed in the Central District of California. The Attorney General of the United States has made a decision. The United States will not seek the death penalty against Durk Devontae Banks, known to the world as Lil Durk. The Grammy-winning rapper from Chicago faces 3 federal felonies: conspiracy, murder for hire resulting in death, using a firearm in furtherance of a violent crime resulting in death. Each charge carries a maximum sentence of life in federal prison. But one of those charges, murder for hire resulting in death, is a capital eligible offense. That means the federal government could have sought the death penalty. They could have pursued execution. But they chose not to. And that decision, the decision to spare Lil Durk from the possibility of lethal injection, happened quietly, in a single-page court filing, with no explanation, no press conference, no statement, just one line. The Attorney General directs the United States Attorney not to seek the death penalty. This video explains what that means, how federal death penalty decisions actually work, and what happens next in a case that could still end with Lil Durk dying in federal prison. Before we break down the charges, the evidence, the law, and why the death penalty was even on the table, subscribe right now. This video is educational. It explains federal murder for hire law, how capital punishment decisions are made, and what life without parole actually looks like. Hit like. Drop a comment. Should the death penalty have been on the table? Let's start with what actually happened. August 19, 2022, 5:40 p.m. A gas station on West Pico Boulevard, Los Angeles. Across the street from the Beverly Center shopping mall, a Cadillac Escalade pulls into the station. 2 men are inside. One of them is Saviay'a Robinson, 24 years old, from Savannah, Georgia. Robinson is the cousin of rapper Quando Rondo. The Escalade stops at a pump. Robinson gets out, and from behind the gas station, a white BMW sedan accelerates. 3 men wearing ski masks lean out of the windows. They open fire. 18 rounds. Rapid fire. Robinson is struck multiple times. He collapses beside the Escalade. The BMW flees. Bystanders scatter. Within minutes, paramedics arrive. Robinson is transported to Cedars-Sinai Medical Center. He dies from his injuries. The LAPD opens a homicide investigation. And for 2 years, nothing happens. No arrests. No charges. Just a cold case. Until October 2024. Durk Devontae Banks. Born October 19, 1992. Chicago, Illinois. Englewood neighborhood. South Side. One of the most violent neighborhoods in one of the most violent cities in America. Durk grows up surrounded by gang violence. His father is incarcerated for most of his childhood. His mother raises him and his siblings alone. By his teens, Durk is involved in the streets. He joins the Black Disciples gang. He starts rapping. And by the early 2010s, he is one of the pioneers of Chicago drill music, a subgenre of rap characterized by dark, violent, hyperlocal storytelling about gang life. Durk founds a rap collective called Only the Family, ODF. The collective becomes a label, a brand, a brotherhood, and Durk becomes a star. By 2024, Lil Durk is a Grammy Award winner. His song All My Life, featuring J. Cole, wins Best Melodic Rap Performance. He has collaborated with Drake, Kanye West, Lil Baby, Polo G. He has 3 top 10 songs on the Billboard Hot 100. He is worth millions. And he is still, according to federal prosecutors, operating like a gang leader, ordering hits, paying for murders, using his wealth and influence to fund violence across state lines. To understand the August 2022 shooting, you have to go back to November 6, 2020. Atlanta, Georgia. Outside a nightclub called Monaco Hookah Lounge. Around 3 a.m., a fight breaks out. On one side, King Von. Real name, Davon Daquan Bennett. A rapper signed to Lil Durk's OTF label. On the other side, Quando Rondo. Real name, Tiquian Terrell Bowman. A rapper from Savannah, Georgia. The fight escalates. Punches are thrown. And then, guns are drawn. A member of Quando Rondo's crew, a man named Timothy Leaks, pulls a firearm. He shoots King Vaughn multiple times. Vaughn collapses. He is rushed to the hospital. He dies from his injuries. He is 26 years old. Timothy Leaks is arrested and charged with felony murder. He claims self-defense. The case is still pending. But for Lil Durk, King Vaughn's death is personal. Vaughn was not just an artist on his label. He was Durk's close friend, his brother. And according to federal prosecutors, Durk made it known that he would pay a bounty to anyone who killed Quando Rondo. That bounty, that open contract on Rondo's life, is what the federal government says led to the shooting on August 19, 2022. October 17, 2024. 5 men are arrested by federal agents in Chicago. Kayvon London Grant, DeAndre Dontrell Wilson, Keith Jones, David Brian Lindsay, Asa Houston. All 5 are charged with conspiracy to commit murder for hire resulting in death. All 5 are alleged members or associates of OTF. The indictment alleges that these 5 men, acting under orders from Lil Durk, flew from Chicago to California on August 18, 2022, one day before the shooting, that they tracked Quando Rondo across Los Angeles, that they followed him to a marijuana dispensary, to a clothing store in West Hollywood, and finally, to the gas station on West Pico Boulevard, where they opened fire and killed his cousin. The same day the 5 men are arrested, October 17, 2024, Lil Durk is arrested in Miami. He is at Miami International Airport, about to board a private jet. Destination, Italy. Federal agents stop him. He is taken into custody. He is charged with 1 count of conspiracy, and he is held without bond. Hold on, before we break down the federal charges and why the death penalty was on the table, I need you to subscribe if you haven't already. Because what happens next, the superseding indictment, the evidence the FBI collected, and how federal murder for hire law actually works, is the part that explains why this case is so serious. Drop a comment. Do you think Lil Durk ordered the hit? Keep watching. November 7, 2024. A federal grand jury in the Central District of California returns a superseding indictment. This is not the original indictment. This is an upgraded version. It adds Lil Durk as the lead defendant, and it adds 2 additional charges. Count 1, conspiracy. Count 2, use of interstate facilities to commit murder for hire resulting in death. Count 3, using, carrying, and discharging firearms and a machine gun and possession of such firearms in furtherance of a crime of violence resulting in death. Each count is explained in detail in the indictment, and each count is built on evidence collected over 2 years of investigation. Bank records, flight records, text messages, wiretaps, surveillance footage, hotel receipts, credit card transactions, and witness testimony. The indictment alleges that on August 18, 2022, one day before the shooting, Lil Durk sent a text message to an OTF associate. The message read, "Don't book no flights under no names involved with me." That message, according to prosecutors, shows consciousness of guilt. It shows Durk knew that what was about to happen needed to be concealed, that the people traveling to California needed to be insulated from him, and that he was orchestrating the operation from a distance. I need to stop here and be very clear about something. Lil Durk has pleaded not guilty to all charges. He has not been convicted of anything. He is presumed innocent until proven guilty in a court of law. That is not a technicality. That is the foundation of the American justice system. And it matters. Because right now, as of February 2026, this case is pending trial. The trial is scheduled for October 14, 2025. And until a jury hears the evidence, deliberates, and returns a verdict, Lil Durk is not guilty. Having said that, the evidence presented in the indictment is detailed. It is specific, and it is built on years of federal investigation. This video explains what that evidence says, what the law says, and what the possible outcomes are. It does not convict anyone. It does not declare guilt. It explains the case, and that distinction matters. Murder for hire is defined under 18 U.S. Code Section 1958. It is a federal crime that occurs when a person travels in interstate or foreign commerce, or uses the mail or any facility of interstate commerce, with the intent that a murder be committed in violation of state or federal law, as consideration for the receipt of or as consideration for a promise or agreement to pay anything of pecuniary value. In plain English, if you cross state lines or use the phone, the internet, or the mail to arrange murder, and you pay someone or promise to pay someone to commit that murder, you have committed a federal crime. The key elements are interstate commerce, payment or promise of payment, and intent to commit murder. If the murder is actually carried out, if someone dies, the charge becomes murder for hire resulting in death. And that charge carries two possible sentences: life in federal prison or death. Under federal law, murder for hire resulting in death is a capital eligible offense. That means the Attorney General can choose to seek the death penalty. Not must, can. And that decision, whether to pursue execution or not, is made at the highest level of the Department of Justice. When a U.S. Attorney's Office charges a defendant with a capital eligible offense, they must notify the Attorney General. The Attorney General, not the prosecutor, decides whether to seek the death penalty. That decision is made after reviewing a recommendation from the Death Penalty Review Committee, a group of senior DOJ officials who evaluate every capital case. The committee considers multiple factors: the nature of the crime, the defendant's criminal history, the strength of the evidence, the impact on the victim's family, mitigating factors, mental illness, childhood trauma, lack of prior violence, and aggravating factors. Was the murder especially heinous? Was it committed for money? Did it involve vulnerable victims? The committee makes a recommendation. The Attorney General reviews it, and the Attorney General makes the final decision. In Lil Durk's case, the Attorney General decided not to seek the death penalty. The motion filed on June 2, 2025 states clearly, the Attorney General for the United States has directed the United States Attorney for the Central District of California not to seek the death penalty in this case. No explanation is given. No reasoning is provided. Just the decision. We do not know why the Attorney General dropped the death penalty. The decision is not public. But based on how these decisions are typically made, there are several possible explanations. First, strength of evidence. If the case against Lil Durk is not airtight, if there is a possibility of acquittal, the DOJ may not want to risk seeking death and then losing the case entirely. Second, defendant's criminal history. Lil Durk has no prior federal convictions. He has no history of violent crime resulting in death. This is his first federal case. For most defendants with no prior record, the DOJ does not seek death. Third, mitigating factors. Lil Durk grew up in extreme poverty in one of the most violent neighborhoods in America. His father was incarcerated. He was surrounded by gang violence from childhood. These are mitigating factors that weigh against execution. Fourth, political considerations. The Biden administration and now the Trump administration have both taken positions on federal death penalty policy. Biden placed a moratorium on federal executions. Trump has historically supported capital punishment, but both administrations have been selective about when to pursue it, and high-profile defendants, especially celebrities, create additional scrutiny. Fifth, plea negotiations. If the DOJ believes Lil Durk might plead guilty in exchange for life without parole, dropping the death penalty makes a plea more likely. And a guilty plea saves time, money, and the risk of losing at trial. Real quick, if you're still watching, you need to subscribe. Because what happens next, the evidence the FBI collected, how wiretaps work, and what life without parole actually means, is the part that explains what Lil Durk is actually facing. Comment below. Should celebrities be treated differently in the justice system? Now, back to the evidence. The FBI's investigation into the August 2022 shooting took over 2 years. And it was comprehensive. Bank records show that on August 18, 2022, one day before the shooting, 5 plane tickets were purchased from Chicago to San Diego using an OTF-affiliated credit card. Flight records confirm that Kayvon London Grant, DeAndre Dontrell Wilson, Keith Jones, David Brian Lindsay, and Asa Houston all boarded those flights. Surveillance footage from San Diego Airport shows all 5 men arriving. Rental car records show they rented 2 vehicles, a white BMW and a black sedan, using credit cards tied to OTF. Hotel records show that Grant checked into a Los Angeles hotel and paid for rooms for the other 4 men using a credit card in Lil Durk's name. Credit card records show that Grant purchased 4 ski masks at a retail store in Los Angeles on August 18th. Text messages, obtained through a federal wiretap, show communication between Grant and Lil Durk on the day of the shooting. And surveillance footage from multiple locations, the marijuana dispensary, the West Hollywood clothing store, and the gas station, shows the white BMW following Quando Rondo's Escalade for hours before the shooting. This is not circumstantial evidence. This is a digital and financial paper trail that connects Lil Durk to every stage of the operation. The most damaging piece of evidence in the indictment is a single text message. On August 18, 2022, the day the 5 men flew from Chicago to California, Lil Durk allegedly sent a text to an associate. The message read, "Don't book no flights under no names involved with me." Prosecutors argue this message shows 3 things. First, Lil Durk knew the 5 men were traveling to commit a crime. Second, he knew that crime needed to be concealed from him. Third, he was actively instructing others to insulate him from the operation. This is consciousness of guilt. It is evidence that Durk knew what was happening and was trying to distance himself from it. Defense attorneys will likely argue the message is ambiguous, that it does not specifically reference the murder, that it could be interpreted as general security advice given Durk's celebrity status. But in a federal courtroom, where juries are instructed to evaluate evidence as a whole, this message combined with the bank records, the flight records, and the surveillance footage creates a compelling narrative. A narrative that says Lil Durk orchestrated this operation from the beginning. Federal wiretaps are not easy to obtain. Under Title III of the Omnibus Crime Control and Safe Streets Act of 1968, law enforcement must meet a high standard to intercept private communications. They must demonstrate to a federal judge that there is probable cause to believe a specific crime is being committed, that normal investigative techniques have been exhausted or are unlikely to succeed, and that the wiretap is necessary to obtain evidence. If the judge approves, the FBI can intercept phone calls, text messages, and electronic communications for a limited period, usually 30 days, renewable if additional evidence justifies it. In Lil Durk's case, the FBI obtained a wiretap on communications between OTF members. That wiretap captured the text message about booking flights. It captured conversations about the operation. And it captured evidence that connected Lil Durk to the conspiracy. Wiretap evidence is powerful because it is real-time. It is the defendant's own words. And it is nearly impossible to challenge in court unless the wiretap was obtained illegally, which defense attorneys will scrutinize. If Lil Durk is convicted, he faces a maximum sentence of life in federal prison without the possibility of parole. That sentence is exactly what it sounds like. No parole board. No review after 15 years. No possibility of early release. No commutation except by presidential pardon, which is extraordinarily rare. Life without parole means Lil Durk will be transferred to a high-security federal penitentiary. He will spend 23 hours a day in a cell. He will have limited contact with other inmates. No television. No internet. No phone calls except under strict supervision. He will age inside that cell. His career will end. His wealth will mean nothing. And he will die decades from now, inside a federal prison. That is the reality of federal life without parole. It is not death row. But for many prisoners, it is worse. As of February 2026, Lil Durk is incarcerated at the Metropolitan Detention Center in Los Angeles. He has been held without bond since his arrest in October 2024. His attorneys have filed multiple bond motions. They have offered a $4.5 million bail package, including $3 million in cash, home detention, and 24/7 private security. Each motion has been denied. Prosecutors argue that Lil Durk is a flight risk, that he was arrested at an airport attempting to flee the country, that he has the financial resources to disappear, and that he poses a danger to the community. The judge has agreed. Lil Durk will remain in federal custody until his trial. That trial is scheduled to begin on October 14, 2025. It is expected to last several weeks, and it will determine whether Lil Durk spends the rest of his life in prison. The 5 men arrested in Chicago in October 2024, Kayvon Grant, DeAndre Wilson, Keith Jones, David Lindsay, and Asa Houston, are all in federal custody. They have been charged with the same 3 counts as Lil Durk: conspiracy, murder for hire resulting in death, firearms charges. Each one faces life in federal prison if convicted, and each one is a potential witness against Lil Durk. Federal prosecutors often offer cooperation agreements to co-defendants. If one of the 5 agrees to testify against Durk, to explain how the operation was planned, who gave the orders, and how the money flowed, that testimony could be devastating. Defense attorneys will argue that cooperating witnesses are unreliable, that they are testifying to reduce their own sentences, that they have an incentive to lie. But juries hear cooperation testimony in federal cases all the time, and it is often the difference between conviction and acquittal. Saviay'a Robinson was 24 years old when he was killed. He was the cousin of Quando Rondo. He was not the intended target. He was collateral damage in a feud between 2 rappers. His family has filed a wrongful death lawsuit against Lil Durk and OTF. The lawsuit alleges that Durk's actions directly caused Robinson's death, that he orchestrated the murder for hire plot, and that he should be held financially liable. The lawsuit is pending, but it adds another layer of legal jeopardy for Lil Durk. Even if he is acquitted in the criminal case, which is unlikely but possible, the wrongful death lawsuit can proceed, and the standard of proof in civil court is lower than in criminal court. A jury in a civil case does not need to find guilt beyond a reasonable doubt. They only need to find liability by a preponderance of the evidence, which means, more likely than not, Lil Durk could be acquitted criminally and still lose millions in a civil lawsuit. Lil Durk's defense team is led by Drew Findling, a high-profile Atlanta attorney known for defending rappers. Findling has represented Young Thug, Gucci Mane, and others. His strategy in Lil Durk's case will likely focus on 3 arguments. First, lack of direct evidence. There is no recording of Lil Durk ordering the murder. There is no witness who heard him say, "Go kill Quando Rondo." The text message is ambiguous. The financial records show payments, but not explicit instructions. Defense will argue that the government's case is built on inference, not proof. Second, attacking the credibility of cooperating witnesses. If any of the 5 co-defendants testify, defense will argue they are lying to save themselves, that they were acting on their own, that Durk had no knowledge of the plot. Third, challenging the wiretap. If the wiretap was obtained improperly, if the FBI did not meet the legal standard, the evidence from the wiretap could be excluded. And without that evidence, the case becomes much harder to prove. This is a winnable case for the defense. Not likely, but winnable. And that is why federal prosecutors drop the death penalty. Because if they lose, if a jury acquits, pursuing death and then losing would be a disaster. Here is what I want you to understand about this case. Lil Durk is not unique. He is not an outlier. He is one of dozens of rappers who have been charged with violent crimes in the past decade. Young Thug, KK Bobby Shmurda, 6ix9ine, YNW Melly, Casanova, Pooh Shiesty. The list goes on. And every time, the same debate erupts. Is this targeting? Is this prosecutorial overreach? Or is this accountability? Because here is the tension. Hip-hop, especially drill music, is built on authenticity, on telling the truth about life in violent neighborhoods, about gang culture, about survival. And when rappers tell those stories, When they rap about violence, about retaliation, about the streets, they gain credibility. They gain fans. They gain wealth. But they also gain attention from law enforcement. And when law enforcement investigates, they find that sometimes the lyrics are not just storytelling. Sometimes they are confessions. Sometimes the violence in the music is real. And that is where the line blurs. Between art and evidence. Between expression and incrimination. Lil Durk's case is not about whether he is a good rapper. It is not about whether his music is influential. It is about whether he used his wealth and his platform to order a murder. That is a factual question, and it will be decided by a jury. King Von's death is the emotional core of this case. Durk and Von were close. Von was not just a signee on OTF. He was Durk's friend, his brother. And Von's death, at the hands of someone in Quando Rondo's crew, created a debt in Durk's mind. That is what prosecutors argue. That Durk believed he had to avenge Von's death. That he had to uphold the code. That letting Von's death go unanswered would be a betrayal. And so, according to the indictment, he put a bounty on Quando Rondo's life. This is the cycle. One death leads to another. One retaliation leads to another. And the cycle never ends. Until someone is arrested. Or someone is dead. Saviay'a Robinson, the man who was killed, had nothing to do with King Von's death. He was not the shooter. He was not involved in the fight. He was just Quando Rondo's cousin. In the wrong place. At the wrong time. With the wrong person. And he paid with his life. That is what this case is about. Not just Lil Durk. Not just the death penalty. But the cost of the cycle. The cost of retaliation. And the cost of believing that violence is the only response to violence. Drill music has been under scrutiny from law enforcement for over a decade. In Chicago, New York, London, and other cities, police have used rap lyrics as evidence in criminal cases. Prosecutors argue that drill lyrics are not art, they are confessions. That when a rapper says, "I caught him at the store and let it bang," that is not metaphor. That is a description of a real crime. Defense attorneys argue this is a violation of the First Amendment. That rap lyrics are artistic expression. That they are no different from a novelist writing about murder or a filmmaker depicting violence. And that using them as evidence criminalizes black art. The debate is unresolved. Courts have split on whether rap lyrics should be admissible as evidence. Some states, like California, have passed laws restricting the use of creative expression in criminal trials. But federally, there is no such protection. And in Lil Durk's case, prosecutors will likely reference his music. They will play songs where he references King Von's death, where he talks about retaliation, where he uses coded language that, they will argue, reflects his real-world actions. Whether that is fair or not, that is for the jury to decide. October 14, 2025. The trial is scheduled to begin in downtown Los Angeles. Federal court. Jury selection will take days. The trial itself will take weeks. Prosecutors will present the financial records, the text messages, the surveillance footage, the testimony of cooperating witnesses. Defense will cross-examine every witness, challenge every piece of evidence, argue that the government has not proven its case beyond a reasonable doubt. And then, the jury will deliberate. If they convict, Lil Durk will be sentenced to life in federal prison without parole. If they acquit, he walks free. And the cycle continues. But there is a third possibility, a plea deal. At any point before the trial, Lil Durk's attorneys can negotiate with prosecutors. They can offer a guilty plea in exchange for a reduced sentence. Life without parole instead of the possibility of additional charges. No trial, no public testimony. Just a plea and closure. That is what happens in most federal cases. Over 90% of federal defendants plead guilty because the evidence is overwhelming and the risk of going to trial is too high. Whether Lil Durk will plead guilty, nobody knows. But if he does, it will happen quietly, in a courtroom, with a judge and a signature. I want to end this video with a question. What is the purpose of the justice system? Is it punishment? Is it deterrence? Is it rehabilitation? Because if it is punishment, then life without parole accomplishes that. Lil Durk will spend the rest of his life in prison. He will never see freedom again. If it is deterrence, then this case is supposed to send a message to other rappers, to other gang members, to other people who believe they can use wealth and influence to order violence. But does it work? Does charging Lil Durk deter the next person? Or does it just create another martyr? Another name in a song? Another chapter in the cycle? And if it is rehabilitation, then the system has already failed. Because there is no rehabilitation in life without parole. There is no path back. There is just a cell, and time, and death. So what is this for? Is it justice for Saviay'a Robinson's family? Is it accountability for Lil Durk? Or is it just the machine grinding forward, processing another case, another defendant, another life, until there is nothing left? I do not have the answer, but I know this. On October 14th, 2025, 12 people will sit in a jury box. They will hear the evidence, and they will decide. Not me, not you, them. And whatever they decide, it will not bring Saviay'a Robinson back. It will not end the cycle. It will just close this chapter, and the cycle will continue. As of February 2026, Lil Durk remains in federal custody at the Metropolitan Detention Center in Los Angeles. He has pleaded not guilty to all charges. His trial is scheduled for October 14th, 2025. The death penalty has been dropped, but he still faces life without parole. His co-defendants are in custody. His legal team is preparing for trial, and the world is watching. Because this is not just about Lil Durk. It is about whether the justice system can hold powerful people accountable, whether wealth and fame protect you, or whether the law applies equally. We will find out in October. On June 2nd, 2025, the Attorney General of the United States decided not to seek the death penalty against Lil Durk. But he still faces 3 federal felonies: conspiracy, murder for hire resulting in death, firearms charges. If convicted, he will spend the rest of his life in federal prison. The trial begins October 14th, 2025, and it will determine whether a Grammy-winning rapper from Chicago becomes another name on the list of artists who never made it out. If you want to understand how the federal justice system actually works, check out my other videos on federal murder for hire law and life without parole. Links on screen. Subscribe, because I break down complex legal cases with accuracy and respect. And comment below. Do you think Lil Durk ordered the hit? Thanks for watching. I'll see you in the next one.